Okay.
SJC-12489, Commonwealth v. Stephen D. West.
Okay, good morning. Attorney Crouch.
Yes, good morning, Your Honors, and may it please the court. Andrew Crouch on behalf of Stephen West, who appeals from a single conviction of first-degree murder out of the Worcester County Superior Court. In the words of the two experts in the case, this was a very unusual case. It was one with a means and method of murder that was extraordinarily unusual. And it was in that circumstance, in the case of compression asphyxia, which finds very few parallels in any other cases that I have located. I'd like to begin by addressing the first issue in the case, namely the Commonwealth's failure to meet its burden to prove by sufficient evidence that the defendant committed the murder by extreme atrocity and cruelty. When we look, we raise several challenges to this particular issue. The first, relates to the issue of malice, and the familiar standard of malice includes that, in circumstances known to the defendant, a reasonable person would have known that the circumstances created a plain and strong likelihood that death would follow. And contrary to what the Commonwealth says in its responsive brief, we're not arguing that cases of compression asphyxia can never meet the standard of extreme atrocity and cruelty, or never meet the standard of first-degree murder. Indeed, there are plenty of cases, where somebody puts a knee on the back of an individual, compressing their chest, or puts a boot on somebody's neck. Those are circumstances that would certainly, lead to a conviction of this sort. This case, though, as both experts noted, was one that it's just an exceedingly rare and unusual case. And the evidence that we saw here involved no evidence, that anybody could point to of a struggle, no, defensive wounds, nothing along those lines. So there's nothing in those particular parts of the circumstance to suggest that the defendant knew in these circumstances that, this particular sexual act was going to lead to, the result that occurred. We also didn't have any particular evidence here.
So, counsel, I'm not understanding that argument that the fact that there are no defensive wounds on the victim or on the defendant mean that he wouldn't know. I don't follow the logic in that.
Sure. So what I'm saying is there were no wounds, period, on either of the two individuals, save for one cut on the victim's neck, that suggests one way or another that this was anything other than consensual. And indeed, the experts themselves said this very well could have been consensual. It's very well, that this individual, who was at least the defendant was at least 425 pounds when he was weighed at the police station. That was the ceiling to which that particular scale went to. He could have been in excess of that he would have had any idea of what was happening to the individual, the victim in this case, who was 125 pounds and 4'9".
That doesn't mean bad act evidence, which you'll get to belie that there was a consensus. I mean, I understand if you line it up perfectly, there could be evidence that it was consensual and it was an accident, and you got that instruction, but you also take a look at the evidence in the light most favorable to the Commonwealth, and there could be an inference that this is an act of rape, which certainly isn't consensual. And if you look at the medical evidence, there was evidence there could be evidence that someone in this position, common sense would say would struggle. So how do you get around the fact that this could be, based on the evidence in the light most favorable to the Commonwealth, a forced sexual event?
Sure. So to take the second part first, the issue with regards to the struggle. The evidence that an individual in this circumstance would have struggled was actually fairly limited. It was limited to, I think, one or two statements made by the defense expert on, I believe, cross-examination. And what they talk about, at that point is that, she would have essentially tried to get this individual off of her. But, the person who, the expert who gave that opinion stated that in these circumstances, they couldn't say for sure that Mr. West would have even noticed it, or that he might have taken it as part of, the role play or the playing during the sexual activity. So in turn, this wasn't a case where.
How is this different from someone holding someone's head underwater?
Sure.
Where common sense would say there'd be a struggle, but maybe not.
I think they are light and day kind of cases. And I think that is an excellent example, as are cases of manual strangulation that we talk about in the brief. And so to get into that particular issue, those are cases where someone intentionally knows that what they are doing at that moment, they are grabbing somebody, say, by the head or the neck and pushing their head underwater. Unequivocally, that is going to meet the standards of extreme atrocity and cruelty. Another circumstance where somebody puts their hands around someone's neck or an item around their neck. This court's cases have said unequivocally, we don't have a big problem saying that those cases meet the standard. And I agree with that. Here, that's not what we have. Even in the best case scenario with these particular experts, with this bizarre and unusual set of circumstances, they said he might not have known. He might have thought that this was part of it. And I would encourage.
But if it's a rape, it's not part of it. So I mean, the inference being that if there's a sexual assault, and then the victim's airway is being compressed, is going to struggle in some respects to get air. Doesn't that, in a light most favorable to the Commonwealth, get them to third prong malice?
I think if we had circumstances that appear in a lot of other cases where we have greater evidence that indeed this was rape, and the Commonwealth is basically relying, as you noted, largely on that prior bad act evidence. And let's go through the prior bad act evidence. There are three sets.
I didn't mean to cut you off, Mr. Crouch, on your other arguments and get into that unless you want to.
Sure. So just to continue on, just along these particular lines, and this feeds also into the prior bad act evidence. We just have, through the expert testimony here and through the forensic evidence, we have a large absence. We just don't really know what happened, in that room, in that time. So what we're having to do is sort of backfill the Commonwealth's case with either prior bad act evidence or some subsequent, consciousness of guilt. But when we look at what the experts themselves say in this particular circumstance, we don't see, this is a complete contrast to the manual strangulation cases where it's plain and clear what the intent is. It's plain and clear what that ultimate result is, and that any reasonable person knows that if you put somebody's head underwater, that's going to lead to a plain and clear chance of death. If you put your hands around someone's neck, same sort of thing. Here, where the evidence is that these two individuals may not have had a lot of experience with this particular position, that these circumstances are such that, the struggle could have occurred, according to the expert, in a 30-second period of time and then not thereafter, or even at the outset, 2 minutes or so. These are circumstances.
Along those lines, can you help me out? What were the limits of what were the time estimates? The shortest amount and the longest amount, please.
The shortest amount was 30 seconds. And then the longest amount could have been, and I believe that was the Commonwealth's witness, then the longest amount was 2 to 3 minute period of time, though they both said that depending on the level of compression, that could have happened quicker. So it's again, based on these circumstances.
Best case for you is 30 seconds.
Best case would be 30 seconds.
Okay.
Otherwise, but the Commonwealth's witness offers no testimony whatsoever as to struggle, as to what the victim would have experienced during that time. It's only this very short couple of sentences in, I believe, So
if we go to a light most favorable to the Commonwealth, and we say that someone's airway was being compressed for 3 minutes, you don't think that would equal some sort of a struggle?
Well, it very well could have, but what I'm saying is here with this particular evidence that we have from the experts, they don't say it. The Commonwealth doesn't actually provide that extra link in the process. And all we have to go on is what the experts say, which is that it could have at the outset, compression asphyxia can generally take as long as 2 to 3 minutes. But in a case with heavy compression, such as they put here, the weight of 1.5 refrigerators on a person and a person of this size, could have happened much quicker. So it's not as if they're saying that 3 minutes, 3 minutes is basically what happened. They said that is what can happen in compression cases, but in a case like this, we don't know. It could have been sooner. It could have been as little as 30 seconds.
So is your argument basically that it relies on too much speculation?
There is a great deal of speculation in this case, and I think that is a straightforward review and point of view as to this particular evidence. And so what happens is, in the absence of that, in the absence of any other physical evidence to give us an understanding of what happened, because both of these experts testify, this, they can't rule out that this was consensual. And they're not saying in a theoretical sense, they literally don't know in this particular case. So my point is to get to, is this a case where this might have been second-degree murder? Is this a case of involuntary manslaughter? Certainly under 33s for the court to consider here. But as I said, this is an incredibly unusual case, and to contend that under reasonable circumstances, a person, where we have no other cases that I've located across the country that involve facts even remotely related to this. It's not like a case of manual strangulation. It's not like a case of putting somebody's head underwater, putting a knee on somebody's neck. These are bizarre circumstances.
And your malice argument dovetails into the atrocity of cruelty sufficiency, correct, Mr. Crouch?
It does, Your Honor. It does. And so in getting into,
it's all the same argument. I don't mean to belittle it, but it's all the same argument regarding speculation in that would affect third prong malice that goes into whether or not they'd be suffering, correct?
I think
Which
that's
guess is the one Canine factor that would be at play here.
I think that is a very fair assessment, Your Honor. And as you said, in terms of Cunene factors, we're not looking at the additional ones. We're essentially looking at, at this point, the defendant's indifference to the suffering of the victim, which, as we noted, may have taken, somewhere between 30 seconds and 2 to 3 minutes. The experts say they can't say that he would have even noticed it or known it or thought it was anything other than, part of the sexual act. This is not a case, this case, as I said, is an outlier. It's a very, sometimes we come here and say, this is an unusual case. This is an unusual case. I don't know that we're going to find another case like this anywhere. At least I, in my searches have not. And, I don't know that one's been before, I've not found one before this court.
Counsel, you've said that this is an unusual case several times, but you don't finish that thought. How does that relate to the inability to find malice or the Cunene factors?
So with respect to the unusualness of the case, we look at, these circumstances known to the defendant. A reasonable person would have known that this created a plain and likely, strong likelihood of death would follow. Other cases, we can look at that and say, yeah, of course, a reasonable person would have thought that because, first of all, we have all these other cases that tell us that. Here, we don't. This is just not something that I think was forced.
You don't think a reasonable person would understand that placing more than 400 pounds on a woman who weighs 125 might cause compression asphyxia?
In this circumstance, as the experts themselves said, he may not have known that. He may have thought that what was happening was.
You're talking about the reasonable person, I thought.
Yes, I'm talking about reasonable person. And as we try to judge what that is, if he, at his size does not, or, sure, does one understand that if you compress somebody down in that position, that could cause this? Certainly during this circumstance, in the circumstances known to him, does he have any awareness that this is happening? Have we ever seen another case where this has happened? Not to my knowledge.
But counsel, can you explain how this relates to a jury finding this? The jury heard all that, right?
The jury did.
And they concluded otherwise. So what's wrong with what they concluded? Where's the error?
Sure. So when we're looking at, there are the two components. Obviously, there's the malice component, which I don't think the standard is that the jury found this, so therefore it is, we don't look at the sufficiency. I think that we can look at this. We look at
sufficiency, but where is this insufficient?
I think it's insufficient. How? Sure. I think it's insufficient when the experts themselves are testifying and when they're in the absence of any other physical evidence that we're looking at this and they're saying this, he may not have known that this was happening.
So he didn't, suggesting we adopt a rule that if an expert is uncontradicted, the jury has to accept their conclusion?
That is certainly not the standard that I'm looking for. I'm just saying I don't mean to repeat myself, but in the unusual circumstances of this case, to sustain the high level of burden with regards to a first degree murder conviction by extreme atrocity and cruelty, finding the malice component here in these circumstances, I think goes against, the weight of justice and against, what should be the standard here. I'm not asking for a different type of standard. I'm just saying under these circumstances, I think that the Commonwealth did not meet that burden And
Well,
in looking,
wait, when you talk about going against the weight of justice, that's a different kind of argument than sufficient.
yes, yeah. So these two arguments, I don't mean to dovetail them or fit them together, but there is, obviously a 33E component here. But I think that, with regards to trying to figure out, the malice component, and what he or what a reasonable person would have known, we have to take into account all of the different circumstances. And there isn't evidence that this person, unlike the manual strangulation cases or putting somebody's head underwater, where somebody is thrashing, where somebody is fighting back in that respect.
Attorney Crouch, I just want to move you along to some of your other arguments because we understand the argument that you're
Sure.
making. Yeah, so what else do you want to tell us?
Certainly. And so to talk about the prior bad act evidence here, which I think is, one of the other major issues, there were three sets. There was the vandalism, there was the debit card, and there were the Google searches here. And so, what happens is the judge, allows in this, these particular parts of evidence. And it's important to sort of contextualize when these things occur. The vandalism here, moves into, 10 months prior to what, the eventual victim's death. And during that time, the victim herself doesn't believe that this vandalism is the result of the defendant's actions. Indeed, tells the police that they believe that it's it's an ex-boyfriend. And then they say, basically she still continues to live there. She socializes with her sister and her brother-in-law, the defendant, eventually moves out to move in with parents, moves in with another friend, and then moves back in. There isn't, and this, kind of comes back into the original argument, there isn't, a level of antipathy. There isn't that, that we sometimes see in these other cases where, there's a history of bad actions between these individuals. Instead, what we're calling prior bad act evidence here, and what the Commonwealth is largely relying on to sort of move this across the finish line, is, this vandalism must have, this vandalism, was what, showed that, that underlying malice, that underlying, antipathy that was there. But the victim herself, said she didn't fear this individual. There wasn't what we have in some of these other cases. The debit card, again, we make arguments in our brief as to what the relevance or what the connection is between some of these particular items and what happened in the ultimate act. This isn't, where there's, evidence that the defendant was at some point violent towards the victim at some point in the past, which is a prior bad act that might make some sense for admission. Instead, there's an errant use of a debit card. She is repaid. And then, perhaps more relevant, we get to the Google searches, which again, to come back to, Justice Gaziano's point, when we're trying to look at what provides evidence that this was rape versus, a consensual sexual episode, we're looking at Google searches, but these Google searches don't suggest, again, the Commonwealth suggests that this sort of moves him along. This shows the escalation in this. And so at some point in 3 months, up to 3 months before the defendant, before this act, before the victim's death, there are these Google searches. But again, these Google searches certainly show a sexual component, but not, again, the level of violence that we see in other cases, the level of threat we see in other cases. So we would suggest, at the outset that, it was an abuse of discretion to admit these, but more importantly, perhaps just the level of detail and the level of evidence that was put on by the Commonwealth in this case with regards to the prior bad act evidence is problematic. We have full days of testimony where multiple witnesses, their sole purpose in the case is to testify at length about these three limited prior bad acts. We have 24 exhibits that come in. And that's because we have an absence of evidence as to what actually happened at the location. And the experts testify that we don't know what happened, that it could have been consensual, that the defendant could not have known.
Mr. Crouch, I appreciate that argument, and I don't want to dismiss it, of course, because you raised it well. I just want to move you to the jury question in your remaining time, which
Sure.
seems to be a key issue. What about this allowing? The judge answered the jury with respect to the causation component, I think appropriately. The problematic part is this allowing language, which kind of implicates a failure to act. Can you explain that to me, please?
Certainly. So we have some
What-
concern.
How should she have answered the question?
So I think that, as the defense points out, there are concerns about, because the jury clearly comes back and has a concern and has that issue and saying, what about causing versus allowing, in terms of the killing. And as he notes, jurors often confuse these elements. These elements are inherently confusing, and we deal with them every day, and they're confusing. For them, they seem to be fixated on the central issue in the case, which is, could he be found guilty of first-degree murder by, having had consensual sex with this individual and then not done anything about it, essentially not acted as the Good Samaritan, not acted in a role. And we see other cases where an individual, more obviously and with intentionality causes somebody harm, a stabbing or whatever, and that person is aspirating, and then they don't do anything about it and that person dies. This is not,
Would that be captured by the accident instruction, Mr. Crouch?
accident can cover some of it, but here I think what the defense attorney was looking for was a more direct answer, and instead, what he got was, just refer back to the instructions. And I think that, especially where the jury comes back only an hour later with the verdict in this case, I think there is a substantial level of confusion and prejudice that comes from not addressing that issue, that no, simply allowing somebody to die is not sufficient to, certainly not sufficient to meet the level of first-degree murder. And then just simply kind of ignoring the question or pushing it off on prior instructions was insufficient. And so I think for the reasons that the defense attorney stated at the time, and for the reasons that we put in our brief, I think that the judge should have gone further and in more directly answering that question.
Okay, any further questions? Thank you.
Thank you.
Attorney King.
Good morning. May it please the court. Michelle King, Assistant District Attorney for the Commonwealth. This court should affirm the first-degree murder conviction of Stephen West. With regard to the malice issue, defense counsel wants to make this.
Ms. King, could you start with the allowing instruction? I think Mr. Crouch raises a good point in that the judge answered part of the question regarding causation, but didn't answer the second part of the question, or the first part of the question, on a failure to act. Was that error?
I'd be happy to address that first, Your Honor. The jury question, as you know, came back as, is causing and or allowing someone's death to take place synonymous with killing? The judge's response to the jury question was actually very pointed. She said, please refer to my instructions on first-degree and second-degree murder. But her second sentence said this: in order to prove any of these crimes, the Commonwealth must prove beyond a reasonable doubt that Stephen West caused, underlined, the death of Alyssa Hayden. So I would suggest to you that by pointing the jurors in the direction of caused, that excludes the question of allowing. But more than that, when she referred the jurors back to her prior instructions, those instructions were riddled with act language, not omission language, but act language. And this case was never about omission, Your Honor. The Commonwealth's theory was that Stephen West raped and then asphyxiated the victim in this case. The defendant wants to make this out as a case of failure to act or omission, but that jury instruction was never requested by either party in the initial jury instructions. No one involved in this case thought that this case was a failure to act or omission case. And the fact that the jury had that question, I can't speculate as to why, but I would suggest to you that the judge answered the question pointedly when she addressed the causation issue. And again, referring them back to the prior instructions was more than sufficient to let them know that it was an act that the defendant had to take place. And if you
Thank,
look,
thank you, Ms. King, for that answer. Let me ask you, and I'll start where you want. I'll next ask you where you wanted to start. Is that, was this a third prong malice case or a second prong malice case? And then the next question will be, what Canine factor was at play here? So if you can answer those questions, please.
yes, Your Honor, this was a third prong malice case that the circumstances known to the defendant or a reasonable person would have known created a strong likelihood that death would follow. The evidence of that is actually quite plentiful. Defense counsel wants to make this out to be some sort of consensual act that occurred between these two parties, and agreed that neither expert was able to rule that out as a possibility. But when you look at evidence or expert witness testimony, you don't look at that in a vacuum. You look at all of the evidence as it came in. And the evidence in this case that this was not a consensual act was actually quite plentiful. You had the testimony of Alyssa Hayden, of Caitlin Hayden, who talked about initially when she met the defendant online. Her sister also, the victim also met the defendant. And at that time, her sister said, the victim said, she had no physical attraction to the defendant whatsoever. Fast forward to the time period when Caitlin Hayden was married to the defendant, and the victim said to her that he was fat and smelly and disgusting. The victim also told her best friend, Philip Harris, lots of things about the defendant. She called him Lardo. She said that he was fat and disgusting. She never exhibited any desire to have sexual relations with him, much less sexual relations where she was tied up in this manner. We also have testimony from Caitlin Hayden, the wife of the defendant, who testified that when she and the defendant had sexual relations, she was mostly on top. And the question came from the prosecutor, during the time that you had sexual relations with him, did he ever put his weight on you? And she said no. And I would suggest to you that that is very good evidence that the defendant knew having sexual relations in that way was a very bad idea with someone who had the stature that his wife and her twin sister had. Both of them being petite, he weighed in excess of 425 pounds. The expert witness said that was approximately the size of 1.5 refrigerators. And I would suggest to you that he knew, or most especially a reasonable person would know, that putting that amount of weight completely on a person of the size of the victim would create a plain and strong likelihood that death would follow. You also have testimony from Nathaniel Steele, who was the victim's boyfriend, that during the course of that night, they had been sexting back and forth. And at some point in that texting conversation, she said that she was afraid. And so when you look at all of those things, not in the vacuum of just the expert witnesses who say, you know, they can't prove by the evidence that it wasn't non-consensual, but you have to look at the entire picture. And when you look at that entire picture, it, along with, even if you don't consider the issue of the vandalism involved, and I would suggest to you that the Google searches and the vandalism add yet another layer of indication here that this defendant had hostility towards the victim, regardless of whether she knew it was there or not. We're looking at his intent, not her knowledge, but his intent. His intent was clear. He wanted to do acts to his sister-in-law. He looked up Google searches along those lines. And a number of months earlier, 8 months earlier, he had vandalized her items and wrote some pretty horrific and disgusting things. And I would urge you to look at those exhibits in the record appendix 38 to 53. They're quite graphic, and it's
And
very
what-
good indication of his intent.
And what's the Canine factor that you rely on?
Yes, Your Honor, there are two Canine factors. The first one is degree of conscious suffering. The expert witnesses here testified that minimally it could have been 30 seconds. It could have been up to 3 minutes if there was complete compression. But if there was not complete compression of her mouth, nose, and chest, it could have been longer. And if you look at the case of Commonwealth v. Mejia, that's a case where the defendant stuffed some tights in a young girl's throat. And it took 3 minutes, according to the expert witness in that case, for the asphyxiation. And the court said in that case that 3 minutes of conscious suffering was enough to meet the standard under Canine. If you also look at Commonwealth v. Linton, in that case, there was 30 seconds of constant or near constant pressure on the victim's airway until she lost consciousness. And the court said that was sufficient for conscious suffering. In addition, there's a second Canine factor, and that's indifference to the victim's suffering. Again, if you look at Commonwealth v. Linton, that case talked about, yes, there was 30 seconds, rather 90 seconds of conscious suffering on the part of the victim, but there was also up to a 6-minute period where if CPR had have been initiated, the victim could potentially have survived. And in this case, we have both experts saying there was a time period of up to 10 minutes. If the defendant would have done something, then the outcome could have been different, and not viewed in the lens of whether or not it was a failure to act, but viewed within the lens of whether or not the defendant was just entirely indifferent to the fact that Alyssa Hayden was lying there limp, is I would suggest you goes to his indifference to her
But
suffering.
would that apply in every homicide case? The failure to render aid?
Um,
To make
not
that
just-
fact meaningless?
Yeah,
So if
not,
someone stabs someone in the street, correct? And then they don't call 911, would that standard apply?
well, not in all cases, Your Honor, because I would suggest to you in some cases, it's obvious that a person is dead instantaneously. And so the question of whether or not you render aid would be meaningless if you knew that somebody was dead.
That's what I'm getting at. So, I mean, those are all where a fatal blow is struck and the person hasn't died yet. I worry that if we extend that standard, we would say that in every case where the person doesn't die immediately, a defendant could be charged with atrocity or cruelty if they don't call the police or EMTs.
Well, two things, Your Honor. First, it wouldn't be an extension because this court has already said that that's a factor. So this court wouldn't be extending it. It would actually just be following prior precedent. But secondly, there's also the Castillo case that recently came down that somewhat changed the Canine factors. And so I would suggest to you that while that doesn't apply in this case, it will apply going forward. And that's something that this court would consider when applying the factors.
Counsel, in this case, did the defendant also take her phone? Are you relying on that in terms of the indifference?
Yes, Your Honor, that in the case more went to his consciousness of guilt, I think is how it was argued, but he did take her phone and again, although I don't think that it was necessarily framed in that way that you're suggesting in the trial court, it was more framed as consciousness of guilt, but I could see how it could be framed in terms of indifferent to her suffering because it took away all possibility if she were to recover that she could reach out for help herself. With regard to the prior bad act evidence, Your Honors, I first want to start with the issue of the ATM card being stolen because in the
Actually,
end,
before you get to that, in your remaining time, did the prosecutor, the trial prosecutor committed error in saying that the victim never had sex that way based upon the episodes of the boyfriend?
Your Honor, I would suggest to you that while the word never may have been a little confusing in that moment, if you look at the entire portion of what the prosecutor is arguing, in that context, he's talking about the victim's sexual relationship with Nathaniel Steele. He's marshaling the evidence that Nathaniel Steele said they never had sexual relations in that position. They never had sexual relations of that type in that home. They certainly never had sexual relations of that type when her one-year-old nephew was down the hallway. And so he takes those three pieces of testimony from Nathaniel Steele and he marshals them and he talks to the jurors about that testimony and knowing that that's what Alyssa Hayden, her sexual relationship looked like. And so I would suggest to you that he's not suggesting that ever in her life she never had sexual relations of that type, because again, if you look at how he raises it in terms of marshaling that evidence, I would suggest to you that it was proper. But if not proper, it was one word in a number of pages of closing argument. The trial judge informed the jurors twice that closing arguments are not evidence, and I would suggest to you that that's sufficient to overcome any small, if at all, misstatement on the part of the prosecutor. With regard to the prior bad evidence, prior bad acts testimony, Your Honors, whether or not to allow such testimonies in the sound discretion of the trial judge and won't be overturned absent clear error. The Commonwealth is entitled, Your Honors, to present a full picture of the events surrounding any incidents. And here, the evidence of the vandalism and the evidence of the defendant's Google searches was highly probative, and there was very little risk of unfair prejudice to the defendant. With regard to the vandalism, Your Honors, the vandalism shows the defendant's hostility towards the victim. And if you look at how the Commonwealth is allowed to show intent, both experts testified that if you look at the evidence, they were unable to determine whether or not the defendant's actions were intentional. And of course, that's largely true in a lot of cases where you have to show intent. But with regard to the vandalism and with regard to the Google searches, they were highly relevant to show or to refute the defendant's assertions, rather, that this was a consensual relationship between he and Alyssa, and it was highly relevant to show his state of mind and hostility. And so specifically—
But what about the ATM stolen card? Can you focus on that for a second?
Yes, Your Honor. The ATM card was part and parcel of the vandalism, but more importantly, when the testimony of the ATM card incident came out, it actually didn't come out as prior bad act. The testimony of Officer Griffin and the testimony of Caitlin Hayden actually demonstrated that it wasn't in fact a bad act whatsoever. It was actually a mistake on the part of the defendant. So the jurors could not have viewed that as a prior bad act. It was viewed as nothing more than a mistake. And so even if initially that was testimony that should have been left out, the way that it came in had no negative connotation on the defendant whatsoever. And so the jurors certainly could not have used that as some negative implication towards the defendant.
So your position is that it was actually irrelevant evidence, but it didn't harm the defendant in any way?
Correct, Your Honor. I also want to point out that when the evidence of the Google searches came in, it was exhibit number 114, that was allowed in without objection. Although that there was initially a motion in limine with regard to the Google searches and the vandalism, that printout of the Google searches came in without objection. So I just wanted to point that out. If there are no further questions, Your Honor, I'll rely on my brief.
Okay, thank you.
All rise. Court is now adjourned. God save the Commonwealth of Massachusetts.